The decision on summary judgment came down, and the judge said library violated the law. His decision didn't specifically address secondary market sales, so it was left open and vague. And so we filed an amicus brief because the SEC was seeking an injunction. And we're going to bring up the injunction because that was the main focus of why I was there today. We all know how the SEC loves for it to be vague so that they have maximum prosecutorial options available to them. So that's why we got involved and said, listen, that's disastrous. And we went to the judge and basically arguing that we don't have a position on disgorgement. That's with library and the SEC on what fine library pays. But this injunction and secondary market sales are very, very important. I stood up with the judge when he gave me the opportunity. I said, listen, I respectfully disagree with you. That injunction is so overbroad that it does bring into secondary market sales into play, for your honor. That's before you. You still, please, have to address this secondary market issue. That article says that your decision reads like you could be saying that LBC is a security in and of itself, the token itself. And judge, if you don't mean that, then we need to clarify something. And then he did something great. He basically looks over at the SEC and says, you agree, right, with him that, imagine that. I want everybody to imagine that a judge looking over at the SEC attorney saying, you agree with Deaton, right? They weren't that happy about it. And the judge said, you got to make a commitment. And he said, let's use an example. And he said, library sold to an investment club who took the LBC and put it in cold storage, a direct sell. The judge said, I found that to be an unregistered securities offering. And you agree with me, right, SEC? And they go, yes. Then the judge said, but if Flipside sells it to someone else in the secondary market, independent of library, you got to agree that that's not, my order doesn't apply to that scenario. And that's the victory that we got. The SEC had to concede that on the record in real time. Then he looked at me and said, amicus, he goes, I'm going to make it clear that my order does not apply to secondary market sales. The devil's in the details. When we see his decision, we'll know how successful this has been or not successful. There'll be a transcript, so everybody will get to read everything that I've been saying. There'll be more detail, obviously, in it. This hearing today, if you think we're getting regulations from Congress soon, then this hearing's irrelevant, right? Because Congress will give us our clarity. If we're not going to get any clarity from Congress, there's not going to be some legislation that says something that defines a security or not a security, if the CFTC has it or whoever. If we're not going to get that for a couple of years, then this hearing was extremely important. And every hearing in crypto will be important because that's the only clarity we will get. So if we get it in writing, like the judge said today, that this decision is only about when the library sold to a specific person on a specific day, the token's not a security, and secondary market sales are not in play because there are people using this technology, that is a huge victory. You take your victories when you can get them. And then nowadays, when we can get any victory in crypto, when we have a war against crypto, you take it. And, I wish Jeremy Kauffman and Library the best. They were valiant fighters. And I should say that when that transcript is released, you saw a little bit of it tonight. When it's released, it should go to every one of the senators and congressmen on the banking committees and the financial services committee, because it is powerful. It is an American entrepreneur standing up and saying, okay, we lost, I'll accept it, but tell me how I can now do this and comply. And the answer is we don't give guidance. And so everybody have a good night.